Hello everyone, and welcome to Family Violence Appellate Project's webinar. Before we get started, a few logistical notes. If you have any technical difficulties viewing this recorded webinar, please email us at training@fvaplaw.org. If this recorded webinar is not accessible to you, please contact us at training@fvaplaw.org, and we'll work with you to provide the material in an accessible format. MCLE credit is available for completing this webinar. To obtain MCLE credit, download the evaluation form located below on the webpage for this training video and email it to training@fvaplaw.org or visit www.fvaplaw.org/training. While there, you can also browse Family Violence Appellate Project's selection of other recorded trainings.
Hi, welcome back. We have 2 more parts to go, but they're pretty fast. And then the discussion. So this part is subpoenas, and then comes immigration. And at the very end, by the way, there is an evaluation form, which we would really like you to fill out. And those are on the outside table. It's short and sweet, but we do want your feedback. So now we're going to talk about subpoenas. Yay, everybody's favorite topic. For this, you're going to need 2 handouts. One is the slides themselves. So there's a cartoon of somebody looking kind of upset at the top right with a bunch of paper. And then also there's a handout which is the handout. The very top one says Interval House Subpoena Policy, Attachment B. And it's a sample letter. So I hope you have both of these in your hands. If not, you can go back to the back table and get whatever it is. Okay, I guess I'm going to assume that you have that. We're looking through these. Yeah. The other one, the very top one, says at the top, Interval House Subpoena Policy, and then Attachment B. And it's 10 pages. Okay. So, responding to subpoenas. So, what do you think of when you hear that word? Yay.
All right.
Ooh, what fun.
It'll work.
How do you do this?
It means work.
Needs work?
It means work.
It means work. Yes, it does. Anything else? Hey,
Jail.
Jail? Going to jail?
Breaking the law.
Breaking the law. Okay. Yeah, we tend to think of subpoenas as kind of stressful. Court orders, of course, documents, etc. These can create a lot of anxiety, so that's why we're going to try to walk you through it and break it down step by step by step. What do you do? So we're going to answer some basic questions in this training. One is a subpoena a court order or not? Some of them are, some of them are not. So we'll talk about that. What do you do before your organization has been served with a subpoena? And then what do you do if it has been served with a subpoena? With this 11 steps guide. So what is a subpoena? It's also spelled kind of funny. Look at that. Subpoena is a written document, and it's asking for one of 2 things. One is they want you or somebody on your staff to come to either a deposition, which is outside of court, or come to court for a hearing or a trial, and then give testimony. Or, number 2, they could be asking for documents like employee records or client records. Or, number 3, combination of those together, and that last one is called a subpoena ducis tecum. Latin. We lawyers like to put Latin because it sounds very impressive. We went to law school and we talk Latin. So, what does the subpoenaing party mean? So that's the person that's asking for the records or the testimony, and the subpoenaed party is the person or organization, like your agency, that's being asked to provide that, the testimony or the documents. You do not want to ignore a subpoena, even though you might be tempted to do that. There's several reasons for that. One is that the party that's subpoenaing you may file a motion with the court to compel compliance. So then it's going to turn into a court order that you have to turn this over. So the court might also issue monetary sanctions, so a fine, like money, that the party, namely you, has to pay. And if the subpoena was issued by a judge or a commissioner by court, then they can hold you in contempt if you don't respond. And do you know what, anybody know what the penalty for contempt is? No, it's only 5 days actually, but you could go to jail, or you might have to pay a fine.
Community service.
Pardon?
For community service.
Community service, okay. Yeah, and also the subpoenaing party, the other side, could bring a civil action against you to recover damages, so money, again, you might have to pay money if you don't respond. But don't panic. Here we have a dog in the half lotus position, meditating. As we'll discuss, responding to a subpoena, it doesn't necessarily mean you have to turn over the information. And if you have anxiety about it, you can contact either the American Bar Association Subpoena Defense Project, which when I checked that online yesterday, lo and behold, Alicia Aiken, the same person that runs the Confidentiality Institute, is the main person behind the ABA Subpoena Defense Project. Or you can contact us, Family Violence Appellate Project, and we will try to help you. So, before you get a subpoena, let's discuss 3 things that you can do. Nice graphic here. Okay. So, tip number 1. Because DV and sexual assault organizations have an obligation to safeguard our clients' data, as we've talked about many times, you need to have written policies about record keeping, data retention, and responding to subpoenas. So that should be part of your general written policies that are given to all the new employees, probably to the volunteers as well. And of course, data retention is how you store your data. That could be either in the cloud, like I mentioned earlier, or in filing cabinets, or in your computers. And you can use this step-by-step guide that we're going to talk about to develop this written policy. Like there's 11 steps here after you get the subpoena. So before you get the subpoena, another thing that you might want to do is make an arrangement with a local attorney who's going to be helping you and advising you. That might be pro bono, so they might be working for free if you're lucky, and if not, then maybe they would provide a discounted rate. Some people have a board member who's an attorney, and that's their contribution to your agency besides helping raise money is to provide legal help for you as an agency, maybe not for individual clients, but for you as your own agency. It's also good to have strong relationships in the community, so you're not the only agency in California, of course, that's working on domestic violence and sexual assault issues, and so it's good to be talking with other agencies that are around you, either geographically or maybe the Legal Advocates Network, which is part of the partnership, a statewide, like an email listserv where you can ask questions and people will say, well, here's what we did about that. Any questions so far? Things to do ahead of time before you might get a subpoena? Okay. So responding to a subpoena, step-by-step guide. Actually, let's have a show of hands. How many agencies here have ever received a subpoena? Wow, almost everybody. So you actually are already experts on this.
How many in a criminal case? How many in a civil case?
And the civil cases were family law cases? Because there's the civil cases like suing somebody for money, like kind of like a car accident, and then there's also the civil cases that are family law cases, or juvenile cases. A lot of juvenile?
Also SSI subpoenas.
Excuse me?
Also SSI.
SSI? Oh,
I don't know if it's fraud or what, but I was saying things.
SSI, that's interesting. Investigating fraud.
Could be, could be overpayments or underpayments if
Overpayments?
they're saying
Uh-huh.
that they have
That's
primary
what's
custody for a kid and needing some assistance for that.
Oh, okay. Yeah, so public benefits in general, there could be overpayments, underpayments, something like that. So step one, there's gonna be 11 steps here. The first one is immediate notification and calendaring. So whoever is supposed to handle subpoenas, so that's what you would have in your written policy. That would be the executive director, or it might be someone else, a director of programs or something like that. You designate that person. And it could also be your legal counsel, your attorney, that's going to be helping you with all this. As soon as anybody in the organization receives a subpoena, you need to tell that person right away. And the subpoena will include a date and a time when the person requesting the documents or testimony wants those. So that needs to be put on the calendar, and then there's a deadline that's before that date to respond to that. To respond. And the deadline is typically very short. We're going to look at a chart in a minute that shows those deadlines. So you have to act quickly. Step two, who issued this subpoena? As you can see on the left side, we have civil cases, which, as I mentioned, that includes most kinds of cases out there. So that's family law cases, civil suits like suits for money, juvenile court. I assume that, I guess administrative stuff would fall under that, SSI. And then on the right, we have the criminal cases. So on the left, the civil cases, the subpoena might be coming from the clerk or the judge, namely the court, or the commissioner, who is, of course, also like a judge, kind of like a junior judge. Or it could actually be from a party, like the abuser, or the party's attorney, not from the clerk. On the other side, the criminal cases, we're seeing them come from clerk, judge, or commissioner, could be the DA or the public defender. They're investigators, and also the defendant's criminal defense attorney, who's maybe not the public defender, but a private attorney. So, was this issued by a judge or commissioner? That's the first step you would ask, the first question you would ask there. If so, then you are dealing with a court order. And that, of course, has more power than the ones that are not court orders. You should still assert the privilege, of course, even if this is coming from a judge, or signed by the judge. And we're going to talk a little bit more about how you're going to do that. But usually you would do that through a formal objection, or a motion to quash, or you could request a protective order. So very different from the restraining orders that we get for our clients, but it's a different kind of protective order. And you can ask that the information that's being requested be reviewed by the judge alone with you and with the client if the client wants to come in the judge's chambers. So that's the court order ones. Step three, what type of case is it? So in civil cases, it's typically the abuser who's trying to get the survivor's information from you. So custody disputes, restraining orders, or possibly personal injury, like if she's suing him for having beat her up or assaulted her. This, of course, could be used against the survivor, the information that you have, as we've talked about before today. So you really need to be very careful to protect the confidentiality of that information, as we keep saying. In juvenile cases, typically the subpoena is going to be coming from the other parent or a guardian ad litem for the child, who's the guardian that's appointed just for the court case. That's what ad litem means. It means for the litigation. Or it might be coming from DCFS, which we also call CPS, or Child Welfare Services. The juvenile court records and the files are confidential, but you still need to assert confidentiality anyway. Domestic violence counselor victim privilege, and the information could be used against the survivor. Again, be very careful. Do not just hand over documents. Absolutely. In criminal cases, typically you're going to get the subpoena from either the prosecutors, that could be the district attorney, or in some places there is a city attorney. But that's mostly in very large cities like Los Angeles and San Diego, or from the defense counsel, either public defender or private defense attorney. don't assume that if you give the information to the prosecutor, that it will stay only with the prosecutor. As I mentioned this morning, there is this U.S. Supreme Court decision called Brady, B-R-A-D-Y, which says that the prosecutor has to turn over anything that might be helpful to the defense. And that's, prosecutors can get in big trouble if they don't do that. You can actually get disbarred over that. So that information could be used against the survivor. So now we're going to look at one of your handouts, the types of subpoenas chart, which is page, let's see, in this handout, that's page 5 of your handout out of 10 pages, called types of subpoenas, and you hold it sideways. There's our FDAP logo at the top left, because we were the ones that developed this particular document. So on the left side, there are different names for the out-of-court subpoenas, like the deposition subpoena for personal appearance. All of those say deposition. So that means going to the office of the attorney for the abuser, and there's a court reporter, and you're going to get deposed, sometimes for hours. I was once deposed for 25 hours. In a family law case, yeah, that's very unusual. Typically, they're limited to 1 day max. And in a case like we're talking about, pardon?
7 hours, yeah. They get you for 25 hours?
Yeah, they got me for 25 over 5 days. But they paid me a lot. Oh, well, if the abuser is paying, in that case, the rates just went up. Then the in-court subpoenas that are over on the right side. So we've got various names here, including the subpoena ducus tecum that I talked about for both showing up to testify and producing documents. So it's important that you correctly identify what type of subpoena, because there's different rules for different subpoenas. For example, how much time must be provided to you to respond to the criminal ones versus the civil ones. And that is actually on, it's on the next page. Oh no, it's on a cheat sheet, which we will get to in just a second. Another chart. So, step 5, identify the parties involved. And for this, I think we're going to look at a sample subpoena, which is near the end of this handout. It's the last 3 pages. And these are two-sided. So this one is obviously a court form, a judicial counsel form. Did you all find that one? There's a place for the court clerk to stamp, the file stamp, but this one is empty right now. Okay, so who's the subpoena party in this case?
Art James, as counsel for Joe Jones.
Yes, so for those of you in the back, this person just said that Art James, who's the attorney up here in the top left, who's counsel for Joe Jones, who is the defendant or respondent in this case, that's who's subpoenaing your records. And we also see Art James's signature on this piece of paper at the bottom right. You see that? Okay. Who is the subpoenaed party?
Stop Domestic Violence Org.
Yes. The name of the group that the organization that you work for, which is a fictional nonprofit here, Stop Domestic Violence Org, which is in San Francisco. That's not a real one. Yeah, and sometimes it'll be an employee of the organization. Like it might say, hey, Rita, executive director of blah, blah. And who is the person whose records are being requested in this case?
Sally Jones.
Sally Jones, yeah. So she's the plaintiff or petitioner in the family law case, Sally Jones versus Joe Jones. And so it's Joe Jones's attorney that wants these records. Does this person have a relationship with your organization? We don't know, just from looking at this. But they might be a current client, they might be a past client. Is it safe to contact Sally Jones? So that's always a good idea, to talk to the client or the former client and say, hello, we just got a subpoena from Art James because he's trying to get your records for your family law case. Then we get to step 6, method and timing for service. This is in another chart. Let's see. Where is this? Oh, yes. It's right before the subpoena. The page before that. Method of service and timing for service. So that page. So as you will see, the method to properly serve, and then you go over in civil actions, it has to be personal service. In criminal actions, you could actually receive it in the mail, but only once it's acknowledged. So in my experience, that's meant that somebody like the DA has called me and said, is it okay if we subpoena you to come and be an expert witness in the case? I say sure. And then they either send somebody to my house who's actually going to personally serve me, or which is wherever, or they might mail it. But in the case of a civil action, they have to personally serve you. So these rules, for example, might be bases for getting rid of a subpoena. That's why we're telling you what the rules are. Then the next question is, when should the subpoena for personal appearance be served? Okay. And as you can see with both of these, the center and the right columns, usually it's typically 10 days. Is seen as a reasonable time to give you notice, to prepare, and to get to this thing. And then when should the subpoena requesting production of documents be served? That's at least 15 days, bottom center column. But in a criminal action, there's only 5 days. So those are the ones where you have to move quickly if they're asking for your documents in a criminal case. Then step 6 is the special notice requirements. This one has to do with a consumer or employee. So this is less common because it could be that they're going to ask for, we don't have consumers in this field, but we certainly have employees or former employees, and those records might be being subpoenaed. That does not apply in criminal cases, and there is the right to privacy, which we have to protect. So before that, in order to do that, let's say there's an employee at your agency called Susie Smith, and she needs to be told ahead of time by being given a notice of privacy rights and a copy of the subpoena, and then they give your agency a copy of the subpoena, saying that trying to get this employee's records. These personal records also include like doctor records, therapist records, attorney records, bank records, those sorts of things. So those are, I think, as I said, less common in our situation because usually we're talking here about client records. Then comes step 7. We need to identify if the subpoena actually is requesting confidential and privileged information. So, brief recap, who's the holder of the DV Counsel Victim Privilege?
Client.
The client, right, not you, not the organization. When can this privileged or confidential information be disclosed? Louder?
The client waives it.
If the client waives the privilege, yes. And of course, you always want that in writing, time limited. When can you be ordered to disclose it? After you assert the privilege in court documents or in court. So in this scenario, you would put the documents in an envelope like this. And then you would go to court. And then you would say to the judge, I'm asserting the domestic violence counselor victim privilege. I have brought the records with me, but they are not disclosable unless you order me to disclose them. And then the judge is supposed to go with you into chambers with the court reporter, and the client, if the client wants to come with you, and the judge looks at the records and then determines whether it does a balancing test, whether the probative value of these records outweighs the value of this client having an ongoing relationship in terms of counseling relationship with you and your organization. And probative value basically means, on a criminal case, it would mean, is it really key to the defense? So if, for example, she said, I think maybe it was my fault, that example I was using this morning, that might be really helpful to the defense. But the judge might decide that because you're the only agency in town and she can't afford a private therapist, that really it's more important to protect that information and allow her to continue to have a relationship with you than to release that to the defense attorney. But this is obviously going to be very different from judge to judge and case to case. And the burden, once you assert this privilege in court, then the burden shifts to the person who's trying to get the records. So Art James now has to get up and argue to the court why the judge should order these records to be released. Art James might argue that it's not confidential because when this client said this to you, actually you were in the reception area at the office and there were 10 other people around, or that it has been waived because she talked to her sister about your conversation, an example that I talked about this morning. And then it is that it might be subject to disclosure, or they might argue there's some other exception. But the judge can't require you to disclose the information until this judge goes into chambers and looks at the records or talks to you. They might just say to you, so what did she actually say to you? And then they make a decision.
Question.
Yes.
So let's say the judge rules that it should be admitted, and I decide to be
Well,
civilly.
it's actually disclosed.
Okay.
Different than admitted, yeah. Disclosed to the other side,
Okay.
yes.
And I decide I'm going to be civilly disobedient and potentially go to jail. At this point, since the
Bring
judge,
your toothbrush with you.
at this point, since the judge has already looked at the records, I mean, do I lose the ability to do that? Can the judge then be like, we don't need you anymore, and admit the documents anyway, since they're physically there? Like, try them out of my hands? I mean, at what point did I lose control over being able to say, I'm still going to protect these, and regardless of what you say?
I don't know. But I have heard of people committing civil disobedience, refusing to comply with some kind of court order, being held in contempt and going to jail and not having to do whatever it was. There was a big deal case from a woman whose child was being sexually abused by the dad, and the mom went to Australia. I don't know if people have heard of this case. Yeah. And eventually they found her, extradited her. I think she was held in jail for a really long time, like 2 years or something. And the whole time she was saying, I'm not telling you where my daughter is. I'm not telling you where my daughter is. And she was just in jail until the trial was eventually over, until the DA finally, I don't remember what they did. I think they convicted her of child abduction. Yeah, but that doesn't really answer your question. But yeah, people do go to jail or.
I think a fine is much more common than fines, when attorneys are supposed to turn over documents to the other side and don't. A fine could be $500 or $1,000. Jail is kind of the last resort, and if you are threatened with criminal contempt, meaning very rarely, but in answer to your question, if the judge has the documents in front of you and is like, okay, we're disclosing them, probably is going to say, good court clerk, go make copies. I mean,
And then it's outside of your control.
yeah, exactly.
Is there a certain point where you want to be careful and not to let what might be overprotection of a privilege that your client is not as worried about for fear of creating an appellate issue? Well, for appeal. Basically, is there the
There might be a liability
fear that,
issue.
well, I can certainly see that, but if you're committing civil disobedience to the point where you withhold records, and then it goes to trial, the other side loses, and he says, well, those records would have changed it, appeal.
It's generally hard to win an appeal regardless.
Well, yeah.
So,
But
appeals
that doesn't
generally
stop it
take
from happening
several
all the
years.
time.
And then if you are winning an appeal on, say, an evidentiary issue, like certain documents weren't produced or admitted,
Right.
generally have to prove those documents would have changed the course
Right.
of the case. It's just a very high burden.
Yeah.
In other words, I think you have more immediate issues to worry about than an appeal.
So it's not really something you've encountered.
No. And also, if, typically, if something's happening in the middle of a hearing or a trial, then you would writ the case rather than appeal the case. So the writ goes up really fast to the appellate court, and appeal goes very slowly.
I suppose it could be argued they would have waived any objection to that particular appellate issue at that time, if they had just let it go to trial.
Well, basically, you would be asking the appellate court to tell the trial court not to disclose this information. You're trying to get an emergency order like this week
Right,
from
right.
the appellate court.
You have to make an
As
interim.
opposed to like you're
or
trying
an
to make some
interlocutory
big
order.
case law
Yeah.
through an appellate decision. Because at that point, it'll be a long time, like Anu said. They take like a year or maybe 2 years
Oh, yeah.
to even get a decision. Very slow. Okay. Okay, example from that handout. So let's look at this one. One with Sally Jones again. And this is going to be a former client, so now we know that about her. And notice on page 2 of this subpoena, under item 2, what is this attorney asking for specifically?
All documents related to Sally Jones.
Yes, any and all documents related to Sally Jones. What's wrong with that request?
Overbroad.
Overbroad. It's extremely broad, yes. So, would these documents be subject to the privilege? Maybe.
Okay, some of them.
Some of them, exactly. Some of them may very well be subject to the privilege. Some of them might not be subject to the privilege. It depends. So, yeah, oftentimes subpoenas are vague or overbroad, and so that's another basis for objecting, besides the timeliness, so they didn't give you enough time, they didn't serve you personally, those sorts of things. Can an organization, in this case the SMAP TV organization, 10 in San Francisco, disclose general information about whether the survivor received services or did not? So this is when I call on this woman that was sitting right in front of me when I was sitting in the back, and she was telling me a really interesting story.
So we had a case in our county.
You want to stand up?
Sure.
People can hear you.
I'm from Yolo
This is
County.
Yolo County.
We had a case in our county where a woman killed her husband, and the defense, her defense was that he was an abuser, and it's a self-defense case. And so we received a subpoena for any and all files related to her
That was from the DA.
from the DA's office, because they were prosecuting her. And our thought was that there was no win for her about these records, because if we said she had never been a client, then they would say there were services available to her and she didn't take advantage of them, and that might hurt her. And then we thought if we said she had been a client, that they would say, look, she had all of these resources, she knew what else to do, she could have got away and she didn't. And so we filed a motion to quash, saying essentially that even answering the question would be a violation of privilege. So we never even said whether or not we had a file. We just said even answering that question is violating privilege. And what they, so she was in jail, and so she knew that we filed this, and our attorney knew we filed it too. And so we felt like if the attorney really wanted us to come out a different way, they would have told us that. So we went to court and won.
Mm-hmm.
Yeah.
Did they ever bring up in that point that if you had provided services, there might be a privilege, but if you hadn't provided services, there would be no privilege to assert?
They could have brought that up, but no, they didn't.
They didn't,
And
okay.
because even at that point, I mean, still the privilege belongs to her, so doesn't she even have the right to say, no, I never went to them? So we just felt like we had a good
Kind of
case.
caught between a rock and a hard place.
Yeah, so anyway, but we did win, and I'm going to send them a copy of that motion to quash if you need it.
Yeah, we'll certainly keep it because a successful motion to quash would be a nice thing to share with others. Yeah.
I think that sounds like a great idea, but I would be worried that that the court would come down probably almost regularly that, oh, if you haven't represented this person or if you haven't provided them services, then there's no privilege to assert or be held by anybody, so you have to answer. I would be worried that they would just
Some
simply
judges
compel a
might
no.
do that, yeah,
Okay,
yeah. It's certainly
I
possible.
would probably expect that,
It
but
seems to me that
seems worth it.
the best route out of that would be for the survivor herself to request in writing to the agency, I do want you to release these because I think it's gonna be helpful. And maybe the DA will drop charges once they realize what's going on.
Hmm.
And then, of course, you have to sign a waiver for you to do that. But if she doesn't do that, then I think what you did sounds fine. Okay, speaking of contacting the client, here we have step 8. Because the client's the holder of the privilege, you should contact the client, and then you should talk to the client about confidentiality and privilege, what can and cannot be disclosed without consent, and that you have to assert this privilege unless she wants to waive it. And you can talk to her about the possible outcomes. Like, if we do give this to the DA, here's how it might backfire against you. So you need to think about that and talk to your defense attorney about whether they think this would be helpful for you or not helpful for you, and then let us know.
Let me ask you a question.
Yes, sure.
So you can still assert privilege here if, even if you've disclosed certain information for it specifically, if you're a mandated reporter and you made a mandated report, you can still assert privilege?
Yes, for the other stuff.
Right.
Not
What,
the child abuse stuff, but the fact that he was beating her in that scenario, the self-defense scenario.
okay, and what if you're not a mandated reporter and you made a report? Can you
Then
still
you're
assert
already in
privilege?
trouble. And you need an
They're
attorney
fast.
to represent you because you just screwed up.
They're Vala Boca.
Can you still assert the privilege? You could try, yes. In general, you should always try to assert the privilege. Yes, no matter what has happened in the past, whether you screwed up or didn't screw up. Until your client says, don't assert the privilege, or dies. Yeah, what to talk to the client about, explain the client's options to challenge. This, we'll talk about formal and informal resolution, what the court could do if a formal challenge is made, and what the options are if the court says no to this motion to quash this formal challenge. And what's the procedure if the client decides that they do want to disclose? And this is when you really should be talking to an attorney if you can.
Do you have a lot of times when a client does want to disclose, but you can look at their file and know, like, this is not in your best interest, and you try to have this conversation with them, you were exited for doing meth in the bathroom, you know, like, there's all these things that are in your file, like, it's not, and they're like, oh, no, I'm fine, I'll just sign the waiver for everything. Does that happen a lot, or is it just?
Has this happened to your clients at your place?
Yeah.
Hypothetically.
I can either confirm or deny if that's how it is.
Well, you could also suggest that the client consult with an attorney about it and see what this attorney is going to advise her to do. Since we can't actually give legal advice, I mean, if you're not an attorney.
Can we say to them, though, in our experience, sometimes when these things are opened up, it can work again? You can say that kind of
Yes,
thing.
you can certainly say, in our experience, when sometimes these things are opened up, then it can backfire. Yeah, what you don't want to do in terms of giving legal advice is you don't want to say should. You should do this, or if I were you, I would do this. That's legal advice. That's not just discussing some options, or here's what we found in the past with other clients. And we have a whole training on that, actually, how to support your clients without giving them legal advice, unauthorized practice of law. So let's assume that your client does not want to disclose all or part of these documents. So there's informal resolution and formal resolution. The informal resolution applies only when it is not a court order. So this one that we've been looking at, that's not a court order, it's signed by the batterer's attorney. So that might be a situation where you could try informal resolution. One option would be to send a letter to Art James, this lawyer that signed this, objecting on the grounds that the subpoena is requesting confidential information and it's protected under the DV Counselor Victim Privilege. And that is actually page 1 of this handout. a sample letter from Integral House. So you can modify that if you would like to, but it has lots of language that we think is useful, and it cites to the California Evidence Code 1037 and following, and so that might be a good template for you. Other grounds could include improper service, like they had to serve you in person, but they sent it in the mail. They didn't give it in time, it's too vague, it's too overbroad. This one is extremely overbroad. They didn't pay your witness fees, which are like tiny. It's kind of, they're kind of a joke. You could also call Art James, this attorney, and talk to them on the phone and see if you can work this out verbally. And if you do, then you always want to write a letter afterwards. Dear Art James, this will confirm our conversation on X date in which you agreed to withdraw the subpoena, blah, 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 whatever that was. If you want tips on what to say, this is again, her name is Alicia Aiken. She wrote this very long 54-page, I think it is, free document that you can get from the ADA website. It's called Protecting Privacy to Enhance Safety Pro Bono Manual. And I just checked that link last night, and it is a good link, and you can easily download that helpful document. You can also call her or email her. So, let's say that doesn't work. The phone call didn't work, the letter didn't work, now you're going to go to court, do a formal resolution called a motion to quash, which the woman from Yolo County was talking about. If they're still demanding that you show up in court. So this is the formal motion that you ask the court to either modify the subpoena, like, hey, that was too broad, it needs to be much more narrow, or just render this whole subpoena null and void, like throw it out. So the court could order that you comply with it, but it could also include a protective order. So it's protecting some of the records and ordering you to disclose some other records. Somebody's nodding back here. You must have run into that. Did you have a protective order? Or just not?
We do it in that.
Oh, you do it all the time? Okay, great. Okay, general grounds to file a motion to quash. Right. One thing you can say, of course, is that it's protected not only under the state law, domestic violence counsel victim privilege, or in your case, attorney-client privilege, but also under these federal statutes that we've been talking about today, VAWA, FIPSA, and VOCA. You can't identify personal information about the clients. In addition to improper service, too vague, too broad, too vague. In order to file such a motion, you have one paper that says notice of motion, another one which is the actual motion where you say it's too broad, et cetera, and then the third document is memorandum of points and authorities. So that's basically the legal argument. Here's the statute that's backing me up. Here's some cases that are on point. And the final thing is a declaration. So that's where you sign it. You say, I'm so-and-so, and I declare that this is too vague and too overbroad. It's all protected because I'm a domestic violence counselor and the privilege applies. And then, of course, you have to sign that under penalty of perjury. So if you need an example, you can contact the ADA Subpoena Defense Project or FF. And pretty soon we'll have this great motion to quash from Yolo County in our files to add to other stuff. And the protective order that I mentioned, that's under the Code of Civil Procedure. So again, you can ask the court to protect some of the records. So there's also a subpoenas cheat sheet in here in your handout, and this is when you're required to serve the motion. So that's page 3 of this handout, another chart. We've pretty much talked about page 1 of that. And page 2 talks about the deadline for you to file. Under civil actions, it's, well actually both of them, it's at least 16 court days before the hearing date that you have to file this motion. So you have to move very quickly. And you can get a hearing date specifically on the motion from the court clerk. So monetary sanctions. As I said earlier, sometimes in your motion to quash, the trial court may award reasonable expenses for seeking a motion in bad faith. So if Art James filed this in bad faith, then you can ask for attorney's fees for your side for having to defend against this. So what if the court says no to your motion to quash? That's when you go up on appeal, as this guy in front was talking about, usually through a writ, because those are the ones that go up really fast, a writ of mandate, where the appellate court is mandating to the trial court, no, you may not order disclosure because of domestic violence, counsel victim privilege, and actually it would be great to have a case. We would have a case sometime, except that writs aren't published, but whatever, we will be in appeal. So you can contact us at that point and we'll talk about what to do. You can also show up at the hearing or the trial and object, as I said, on the basis of the privilege, and then ask to go into chambers with the judge, and it would only be you, the judge, and anybody that the client is authorizing to be there, like their support person, for example. I assume a court reporter. It's not mentioned. So, if the formal challenge has been asserted, does the court have authority to compel disclosure? Yes. The court's doing this balancing test, as I said earlier, and they may decide that it's more important to release the information than to keep it protected, and they may order you to disclose, and that's when you consider appeal. Okay, what if the client does want to disclose all or part of the confidential information? We need to, as we talked about earlier, make sure that the client understands the outcome and the consequences. If the client really does, say that they really want that, they seem to understand it, then you get your waiver form that we looked at this morning and have them fill that out. And it has to be very, very specific. And there's another example of a waiver form in this packet, which is page 2. It's also from Interval House. It's similar to the other one that we looked at this morning. This was the consent to release information. So, after you get all of that, after you get the written consent from the client, then you make sure that your attorney, if you have one helping you, or if not, then presumably your executive director, maybe the chairperson of the board, I don't know, maybe they could help, should review all the documents that you're going to actually turn over, and you might need to redact things, like black them out, get out your black marker, and take out stuff that should not be disclosed, either because the client says no, they don't want to disclose that, or because the client doesn't have authority to disclose that. So what are some of the things the client doesn't have authority to disclose? Shelter location, yes. What else?
Other clients.
Other client information, exactly. And that might be in there because they were in a support group and different people were saying things in the support group, or the names of people just being at this shelter with this client. Or your business information, or information regarding children, mandatory child abuse reports, reports from Department of Child and Family Services or CPS. This is when you really definitely need to talk to Anya or some other attorney that really understands the mandatory reporting laws to make sure that you're keeping things confidential that have to be blacked out. So after you do all of that, yeah, I've already talked about that. Okay. So here's a little hypothetical. The client's in the shelter for 30 days. She leaves, she comes back 6 months later from her services because there's been another incident. She tells the third party, let's say her sister, because we keep using that example, about something that she talked to you about the most recent incident. Then you get a subpoena from the abuser's attorney, and they want to know all communications, just like in this example here, all communications. What should you do?
Object and assert the privilege.
Object, assert the privilege. What about the fact that this client has talked to her sister about your discussion, about your communications? Does she waive the privilege?
That may waive the privilege for the later incident.
She probably has waived the privilege for that particular incident. However, you should still assert the privilege because we just assert the privilege. That's the bottom line.
Yes, to prove she waived it.
Yeah, so first you talk to the client. Then you file a motion to quash or appear and show up and say, you're asserting privilege. And then you should say that the subpoena should apply only to, I actually think this is incorrect, it should be the earlier communications, because the recent one, she's probably waived it. But you could assert it regarding all communications, and then let the other side argue that she has waived the privilege by talking to her sister about some of it. What if you don't have the information at all? And that was actually one of the points that was made by our Yolo County friend. She said to me, well, what if there is no file? So then you contact the subpoenaing party or their attorney. In this case, we have our James and his client, Joe Jones, explained that while the privilege prevents you from disclosing whether this Sally Jones came or not to your organization, that your policy is to destroy all documents after X period. So if he's asking for things from a former client, and that was 4 years ago, and you usually destroy things, like shred them after 3 years, that you don't have these documents anymore. So that's another thing your organization can talk about, is how long do you want to keep the documents. Some of them might be helpful for your clients, for you to hold on to, but it also might be good to shred things on some regular basis.
Whichever year time frame they want.
Yes, or you just make up the policy,
This is policy
depending on,
this
yeah, our policy is to shred them after 6 weeks.
Right.
It was 8 weeks, so yeah, we don't have those anymore. Yeah. So here's your checklist with the 11 steps that we just talked about. Thank you. Oh, another question, and then we'll take another stand up and sit down 5-minute break. Yes.
So what if the advocate is being subpoenaed because, not necessarily during the investigation, but at the law enforcement agency they were translating?
Uh-oh.
So not during the actual, like they're not for the investigative purposes, like not during the investigation, but for simple questions like about, car seats and blah, 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 but they want to make sure that that conversation is what it was said.
In general, it's not good to wear 2 hats. If you're the DV advocate, it's not good to also be the interpreter, because then you run into this problem. But if that's already happened, I guess I would still assert the privilege and let the other side argue that you were there as an interpreter and not as a counselor. But yeah, I would assert the privilege. But try to get another person to interpret in the first place.
I think something we forget also is that memory is a tricky thing. And I personally don't rely on my memory for anything if I don't have something written to jog it. And by the time we're getting subpoenaed, it's probably a long time since a casual conversation that I'm not going to swear that I remember verbatim occurred.
Yeah.
Right? So I think we forget that too. I don't remember, and so I don't feel comfortable answering that question as valid.
That might be part of the informal resolution where you call up Art James and you say, that was 2 years ago.
I can neither confirm nor deny.
Nobody,
What
yeah,
was that?
nobody remembers, frankly.
So then again too, if the subpoena says we want her file, and we have other documents about her somewhere else, i.e. maybe we keep all of our CPS files someplace else. So in that case, if it's specific to that, we would just give them the file, because they asked for her file.
No, you're going to assert the privilege.
Aside from
You're
that
not
part.
going to get in the way.
Aside from that part, if it ever got to that point where I had to bring something into court.
Or she waived.
Or she wait.
Uh-huh.
Okay.
Even still, all these guys,
Pardon?
even if they do waive, like, I would still call you guys just to like, so that's another idea.
Yeah. Okay, we're going to take a 5-minute break.
Thank you for watching our webinar. MCLE credit is available for completing this webinar. To obtain MCLE credit, download the evaluation form located below on the webpage for this training video and email it to training@fvaplaw.org or visit www.fvaplaw.org/training. While there, you can also browse Family Violence Appellate Project's selection of other recorded trainings. A copy of the training slides and any accompanying materials is available on the webpage for this training video or by emailing training@fvaplaw.org. Thank you again for watching. this webinar is now concluded.